Hi there, Jim Montgomery again, jamesmontgomerylaw.com. Let's talk about your business for just a second. If you probably saw the last video that I did and you got a little bit of the background. We buy and sell businesses. We've dealt with $200 million worth of businesses and sales in the last 5-6 years. So we've seen a lot of what we're talking about. Not only that, I was a trial lawyer for a long time. I used to take them apart at the courthouse. Got involved at the beginning so we could solve some of those problems and not have to do it over and over again. But let's talk about the first topic today. Let's talk about the formation of your business. Everybody gets together. It's easy on a handshake to say, hey, let's go do this. We got a great product. We're going to whatever. And 2 or 3 of you get together and say, hey, I'm going to do the work. I'm going to be the salesperson. Hey, I'll put the money up. I'm going to be the money guy in the deal. And maybe you'll have sweat equity, whatever the situation is. One of the things that we'll talk about in the next video is going to be the shareholder agreements and how you deal with each other and how you play together nice. Today we want to talk about when you form your business, how do you keep from getting yourself in real trouble? Okay. Now there are a couple of different kinds of businesses. One is the sole proprietorship. And if you have used the sole proprietorship, then you are fully liable for everything that can happen. That is, your tax ID number is your social security number. You don't have any kind of a corporate setup whatsoever. It's just you, and you're the one who gets sued. You're the one that does the work, and you see a lot of business that get started this way. Don't do that. That's not what you want to do. It also does not give you the best tax benefits. The second one is going to be the general partnership, where you guys all get together. Well, unfortunately, general partnerships just a bunch of sole proprietors doing business together. And that's the way general partnerships operate. You're all liable for everything, not only what you did, but what he did over there. You don't want to do that either. The next one's called a limited partnership. And that's where you've got a general partner who can either be an individual or a corporation, owns just a very small amount, but they're the ones that have all the liability. Then you've got limited partners. A lot of real estate deals are set up this way, so that you've got a general partner who's actually running things. And then you have the doctor or whoever is the investor who comes in and puts up money, but they only have limited liability. They don't have to put any more money in necessarily, and they can't really be sued for what happens in the partnership. That's a better deal. In today's world, we also have, though, what's called a limited liability company. And a limited liability company is a fairly new animal. It used to be that the only thing you could do was either a partnership or corporation. I'm going to come to corporations in just a minute. We'll come back to that. But a limited liability company is basically a partnership, but it has been given limited liability. It has a manager, or it can be managed by its members. The members vote on what's going to be done, unless it's manager managed, and then the manager decides. But usually the manager is also going back to the members to say, here's what I want to do. What do you think? That's always a good way to do it. That way you stay out of trouble. Now, the limited liability company is pretty good from an asset protection basis. It's the one I really use most of the time. You've got a situation where you have no liability to third parties unless you are, for example, you could be a salesman and you might have individual liability because you've lied in the sale, fraud, whatever you want to call it, and they could sue you for making misrepresentations. That one doesn't arise that much. Usually they want to sue the limited liability company. Well, a limited liability company can be liable for whatever it did, but it's only liable to the extent of the assets that are inside of that entity. But you are an individual member. You don't own stock like you would in a regular corporation, but we have what's called membership interests. And frankly, it's very similar. We even do what looks like a stock certificate for the member, but you own a percentage interest or a number of units in that limited liability company. But what happens is you are able to own that, but it's like you're a partner in a partnership, as opposed to being in a corporation where you own a stock certificate. If I get a judgment against you individually because you were in a traffic accident or you were in some situation where you had individual liability, you signed a guarantee someplace for a lease, and you got sued individually and you're going to have to pay it, and they got a money judgment against you. Because frankly, in most circumstances, you got enough insurance where this is not likely to happen so that you're covered, but there are circumstances like guarantees where you might not have any insurance that covers what you're doing. But let's assume there is a judgment against you. Well, if I'm the creditor, I can come to you and I can take your stock away if you're a corporation. And I will now own your corporation because I own the stock. Just as if this was GM and I was able to get a judgment against all the shareholders of GM or enough to gain control, and I collected by taking that stock away to satisfy my judgment, I would now control GM. Take that to be your corporation, whatever your corporation has. As opposed to a limited liability company where it's different. You own that membership certificate. Now it looks like a stock certificate. But there's a special thing that goes with limited liability companies. And that is what's called a charging order. And you're entitled to get money out of your company. And we're not talking about salary, we're talking about distributions. And let's say you're very profitable and you do get distributions on a regular basis. Well, the board or the members are going to get together and vote, and they're going to vote that they're not going to pay you because they don't want that money to go to that creditor. They're going to hold that money within the company. Now, there are other ways you can get money out, salary, etc., that the creditor may not be able to get to. There may be expenses that the company can pay for you, but they can't have your stock. What's worse is they get this charging order. So let's say you were supposed to get $100,000 in a distribution. Company votes, no, we're not going to pay you the distribution. Well, guess who gets the tax bill for the money you were not receiving? Not you, the creditor, because the creditor was trying to take your interest in the company. So they have what's called phantom income. They have that $100,000 they've got to report on their tax return, but they didn't get the money and they can't have any money to pay the taxes with. Now, I don't know about you, but if I were the creditor, that made me stop and think, do I really want to go do this? Doesn't sound like a very good idea to me. Well, that's actually what happens usually. So that's limited liability companies. We also have something called series LLCs, which is where you really form one and then you can kind of subdivide it as you go. Entirely different topic, not what we're going to discuss today. If you need to know more about that, just get in touch with me in my office, 690-3700 or jemlaw@mac.com. So let's go to the last one now. Corporations. Good for limited liability. Again, you can't be sued just because you're a stockholder. You can't be sued just because you're an officer and a director. There are certain circumstances where that could be the case. But normally that's not what's going to happen. They sue the entity itself. But we've already highlighted the problem with why that's not really a good asset protection device necessarily, because you can lose your stock certificate to a creditor. We haven't talked much about taxation. Taxation really goes with some of the different forms. Partnerships get partnership taxation. Corporations can either be what's called a C Corp, which is a regular corp, which means that the corporation pays all the taxes. Everything stays in the corporation. You pay yourselves either through distributions or through salary. Has the potential, though, of having some double taxation there because you're taking money out, and if it's done as a distribution, you may pay tax on something that the corporation has already paid tax on. So that's not necessarily the best way, but it is the form that we see most of the time. For example, if you think you're going to go public and you want to be able to be in a situation to go public or to sell to a publicly traded company, you may very well want to be a C Corp so that you fit and be a stock company so that you fit what they are, because they want to buy something that's like them, not something else. The other option, though, is what's called an S Corp for taxation. Now, this is not the form of the company. This is how it's taxed. That's sometimes hard to just understand the difference there. But it is where the taxes are all passed through. You get what's called a K-1, which you take to your tax preparer and they put on there, and it has what your share of everything was. That's how depreciation gets passed through. That's how things that flow through to your individual tax return, as opposed to being paid at the corporate level. It just files an informational return at the corporation level. The LLC has the benefit that it can be taxed as a partnership, which is actually the default. If you don't do an election, you're going to be taxed as a partnership. LLC files a partnership tax return, and you get a K-1. Things pass through to you. The other option is you can actually do an S election and do the same type of, it's basically the same kind of taxation, but it passes through. The company files, though, a small business or an S return, and again, you get a K-1. A little bit difference in the taxation, but usually you're going to select one or the other, and that's something you decide with your tax advisor at the time that you're getting started. So that's kind of the overall there. If you're really looking at it, you're probably going to be looking at an LLC. That's usually the normal way in today's world. It's become kind of the way to do things, unless you're going to grow bigger, raise lots of money, do things like that, where you actually want to be a stock corporation. You can do the capital raising, etc., in an LLC. It's just if you're going to go to the big league, so to speak, you may want to start off and get ready to go to the big leagues at the beginning. So that's kind of the difference of the formations. You don't want to be a solo practitioner. You don't want to be a solo entrepreneur. You probably don't want to be a general partnership. Limited partnership for real estate deals pretty good, but for most other transactions, that's no longer something that we would normally recommend. LLC is probably what you want to be, but then there are circumstances where you might want to be a stock corporation. Now, what we talked about so far doesn't deal with buy-sell agreements, shareholder agreements, the things that give you the operating rules for what you're going to be doing. The company has a company agreement, the liability company has a company agreement, the corporation has a set of bylaws. That's the topic of another video. Glad you enjoyed it today. I enjoyed talking with you. I hope you got some good out of it. Got to give you that little reminder, though. I can't give you legal advice on this little video. I hope you didn't think you were going to get real good legal advice on a free video, because if you did, well, there are probably other things we need to be talking about anyway. But if you've got issues that you want to deal with, how to get formed, that sort of thing, just give us a call, 690-3700, or website is jamesmontgomerylaw.com, or you can email me directly at jemlaw@mac.com, jemlaw@mac.com. Have a great day.